Greetings, salutations, my fellow sovereigns. This is Vocational Science of Freedom, Saturday Night Civics and Sovereignty class, and tonight we'll be continuing our reading from A Practical Treatise upon the Law of Judicial Writs and Process in Civil and Criminal Cases. And this was written in 1895, and this is a treatise that is the time of which the common law was in its heyday, working properly the way it's supposed to be working, and shows us what our power is in our own courts of record before they brought in the Federal Reserve in 1913, along with a bunch of other things like the IRS and a few other things, and then what they really did in 33 and totally destroyed the common law. So looking up and reading these important older treatises gives us insight into how our proper system of common law is supposed to work and how we are supposed to work it. Because you're never going to find this information in any sort of regular statutes, acts, ordinances, or codes, and you're not going to find it in any modern law books at all, because they want all of this knowledge occulted so that you have no idea what is going on and you have no idea of what your rights are. Okay, we left off at page 219 in the treatise itself. It is page 161, and we're going to come to the section, start off with part 3, and part 3 is going to be about the service and execution. Chapter 21 starts out by whom and when process may be executed. Okay, so what is the execution of process? That's the execution of an order of the court. So say the court said the plaintiff has the right to go back and get his horse from said defendant or a house or whatnot. Then the sheriff would come and execute that writ and say, you now must give up the horse. That's called execution. And nowadays they're simply, in the statutory world and world of equity, most of the time these writs are simply just called writs of execution. So, having considered and discussed the issuing and validity of process, we now come to execution, which will be the subject of the third part of this book. A valid writ having issued, yet it is of no avail unless one duly authorized exercise some power and do some act under it. Okay, so just a little bit of a vocabulary there to unravel. Valid writ having issued. What's something that issues? Something that issues from the court is something that has been done, and it is a order of the court to go do X. You can also have things issue from the court, say orders, judgments, subpoenas, warrants also issue. And yet it is of no avail unless one duly authorized. Now, what does duly mean? Duly means that it is in accordance with both the common law and equity. So when one is duly served, means it took care of the process situation or the rules of process by both equity and by common law. If you say are in court and you object to something, the judge may say duly noted. And what does he mean by that? He means that your objection is in accordance or has been recognized as both under the common law and equity. Okay, unless one duly authorized exercise some power and do some act under it. Who are empowered to execute process, what is the extent of their authority and liability, and who and what are subject to the commands of writs are questions of the very first importance and are to be answered through a mass of confusing and conflicting decisions. The decisions regarding process and what is and what is not valid really come down to common sense, because when you think about common law, the first thing that should come into your mind is common sense. Common law is common sense in a nutshell. It's the immemorial practice of the people and how they function in their society, and it should always be done to do justice, in a sense. So, Section 95 by Sheriff Sheriffs and constables are the officers especially authorized to enforce process and have been since the establishment of these offices. Sometimes, and under some circumstances, the same power may be exercised by marshals, coroners, and individuals. The last named acting generally under statutory authority or being specially empowered for the purpose and being termed an, quote, indifferent person, close quote, which indicates he is not a party to or interested in the proceedings in which the writ issued. That is very important. No one can ever serve their own process. So if you're a plaintiff, you must be indifferent. If somebody else serves it for you, they must be indifferent. Now, the sheriffs and the officers are always considered to be indifferent. Obviously, unless they are actually named in the suit, and we'll get into that. But so basically, anyone who's over the age of 18 can serve certain process. Now, what we're talking about here in process that is executed, there is a big difference between simply serving one a notice of lawsuit and actually executing an order from the court, because it's a whole lot different when, say, your 18-year-old cousin goes and serves some guy down the street a lawsuit for you, compared to when you're asking your 18-year-old cousin to go and execute a writ of execution and go repo somebody's car and possibly get shot at. Those are two vastly different things. Now, we'll get into when the 18-year-old can actually go and repo the car. That's in here as well. But you got to keep that in mind, that it's a vastly different thing to truly execute something of which power is required compared to just giving somebody something. Just giving them a lawsuit and saying, here, you're served, and then walk away. Any 18-year-old can do that and are authorized to do that under statute and at law and under common law. But what this chapter is going to talk about is when they can actually execute a power and basically take a right away from someone else, but that has already been determined by the court to be valid to do so, whatever that may be. Okay. All right. So it has been the inclination of the law to avoid entrusting the execution of process to parties to a suit, right? Which is what I just said. And I'm going to skip over all these specific cases, and I'm going to skip down to the coroner, because what a lot of these cases are going to be, like, kind of specificity as to who can do what when, and the requirement of putting onto the writ that, okay, only the sheriff can do it, or the sheriff and the coroner can do it, and so on and so forth. So I'm going to skip all that specificity and just get down to the bare bones of the next one. All right. So by constable, 96, the office of constable is of early creation. Originally, his duties pertained exclusively to those of a peace officer. He is yet specially charged with the execution of criminal process, but is also empowered by statute to serve and enforce civil writs, especially those issued by a justice of the peace. His duties and powers within his jurisdiction are governed much by the same rules applicable to the service of process by sheriffs. By marshal and coroner, section 97. Duties of marshals very greatly concern the execution of criminal process, but this officer is also frequently charged with the enforcement of civil writs. Coroners act under civil process in cases of emergency only, being empowered to serve writs when the sheriff is disqualified for doing so. Now, this being also this aspect by statute. So it says coroners act under civil process only when being empowered to do so. Well, or I should say, only when the sheriff is disqualified from doing so. Do we have anyone qualified out here any longer to serve a common law writ? The answer is no, because what they've done by Roman civil law is they've created these various different acts, and usually in most of the states I've seen them called All Writs Act, or I've seen that in at least a few states. They'll call it like the All Writs Act, saying that all writs are abolished. Well, they're abolished by the aspect that you can't, and no one knows how to, except those that learn here, open and properly operate a common law court of record. So They deemed everybody infants. They deemed all of your babies registered, considered all of us barred from the common law, stole all of our gold. We don't have any capacity to pay proper debt. And so we're all considered bankrupts, and all of the other presumptions that, we've spoken about here many times. And if anybody wishes to learn the presumptions, the long list of said, just watch the presumptions class on the VSOF. And so they've got us into all these presumptions. And so they're saying, okay, well, we're going to put down into statute and Roman civil law, statutes, acts, ordinances, and codes, these all writs acts, which say that all writs are abolished. Well, they're abolished from the standpoint that a person, meaning an infant, wouldn't be able to create them, which is true. An infant wouldn't be able to create them in the first place anyway. But they make it seem as though, oh, this is a new thing and you're all persons. A person may not X, Y, Z, la, la, la. And we all know what a person is, defined by 1 USC subsection 8. So it's not that we do not have the capacity to do it. It's that they have done everything they can possibly do to strip us of our superior form of law, our common law, which is always above their Roman civil law, unless we have waived it specifically by contract. But those of us who have done the Vocational Science of Freedom Statuscorrection, we get rid of all those contracts anyway. So this is what they're dealing with. So the coroners, what they're talking about here under civil process are aspects of that usually statutorily only when the sheriff is disqualified. Okay, well, they're all disqualified right now because none of them are acting at law, and very few of them, as Viper has found, even have proper oaths of office. So when we do our Vocational Science Freedom Statuscorrection and we appoint someone as a judicial coroner of our own house, do those judicial coroners have the capacity to serve and execute writs from our courts of record, bypassing the sheriff? The answer is yes. Because necessity knows no law. That's a maxim of law, okay? And so whenever there's a lockout of a capacity or they've taken away, well, then by necessity you have the right to create whatever remedy you need to fix the problem. Because there's also another maxim at law which states that there shall not be no remedy, meaning if a remedy doesn't exist, you can create one at common law. All right, I'm going to skip down to the next section we got. By persons, not officers. It is the policy of the law to prohibit the service of process by a party to a case or by a person interested in it, as we stated. But this is a matter largely of statutory regulation. Right. That a person is an inhabitant of a town that is a party to the action does not disqualify him for serving process. Service of a summons by a party to which the cause is nothing more than a voidable irregularity to which objection cannot be made after judgment. The California, and this is an interesting thing, the California Practice Act, which made sex, color, age, and citizenship essential to the competency of a third person to serve process, does not include cases where the service is by publication or by making a deposit of the summons and complaint in the post office. Okay, so that needs some clarification. So by persons, not officers, but this is a matter largely of statutory regulation. So they tell you right off the bat that it's the statutes that are trying to control this aspect of it. Okay. That a person is an inhabitant of a town, okay, whatever. Service of a summons by a party to the cause is nothing more than a voidable irregularity to which objection cannot be made after judgment. All right, so service of summons by a party to the cause. If you were a party to the cause and you served it, then they're saying it is nothing more than a voidable irregularity. Well, in some statutes, it'll specifically state absolutely the opposite. So just be wary of that. And then this California thing is, I thought, fascinating. California Practice Act, which made, and I don't know if this is still in full force and effect, it may very well be, which made sex, meaning probably only men, color, which probably meant only white people, age, and citizenship, age being probably 18, or they might have just simply put into the statute come of full age, possibly, and citizenship, lowercase c, citizenship, which means state citizenship, essential to the competency of a third person to serve process, does not include cases where the service is by publication. Okay, what's service by publication? That's where you've tried to serve them multiple times, personal service. You went to their house multiple times. You sign an affidavit stating so. Hey, I tried on April 1st. I tried on April 5th. I tried on April 11th. This is to the last known address where their domicile is. I've tried at their work, so on and so forth. Okay. Once you bring that back to the clerk and you say, look, I've tried all these various different places. I can't find this fucker. They'll go, okay, you can't find him. Great. We'll now allow you to do what is called service by publication. Service by publication is where you post it into the state newspaper, or let's put it this way, whatever newspaper by statutory regulation is declared to be the newspaper for service of publication. So you're throwing it into a statewide circulated newspaper saying John Doe is being served with or is being sued by Mary Rowe for X. That's service by publication. Now, they really, really, really don't like that because obviously no one reads the newspaper anymore. But they didn't even like it when everybody read the newspaper because obviously it's not something that a lot of people are going to see nor check out and can easily be missed. But so be it. I'm just explaining what it is. Okay. Or by making a deposit of the summons and complaint in the post office. That would now be what we would do by registered mail with return receipt requested. So you'd want to do it registered so that there is a signature for every single man or woman who ever touches that package, all the way through the postal service, plus the last one that it's handed to. So in a sense, with doing that, you are giving the power to the post office to actually serve your documents because it should come back with a signature. Now, this is also slightly frowned upon as well, but if you have no other way to find whoever the hell it is that you're supposed to be serving, you can do this. And there are statutes that determine when that's available, when that's possible, and at common law, it would just be based upon logic and reason. You know, I tried 5 times, la la la. Okay, yep, I sent him by the post office to his last known address, registered mail. And if it does get there and then somebody signs for it, if that man or woman signs for it, well, then the signature of it that the postal service worker got the signature from so-and-so, then that would consider to be valid service. Okay. All right, to continue. An indifferent person is one not a party to or interested in the action, as previously stated. I'm just going to skip down here. But a minor is incapacitated for serving process as an indifferent person, and service by him is void. Right. So we cannot have infants serving process, clearly. Okay, skip down the next section. The appointment of an indifferent person is a judicial act and cannot be delegated. Okay, so what the hell are they talking about here? So when the court creates a writ, and let's say the sheriff is indisposed or something, and a coroner can't be found, and so on and so forth. So the court has to specifically appoint an indifferent person. Now, again, this is very much comes up when you have to deal with things that are really executed, saying like going and taking somebody's property. But the court can do that. You can say so-and-so and so-and-so are appointed as indifferent persons to execute this said writ, right? And then name them. That'd be fine as long as the court did it. Okay, so such an appointment on a blank writ is void. Meaning you can't just make it up. It has to come from the judge. It has to have names on it. And there has to be a reason why it was not specifically issued to the sheriff for process or whoever else might be in the area to do that, constable, whatnot. All right, the indifferent person must be named in the writ. A person authorized to serve a writ has all the powers which may be exercised by the officer in executing the same writ, except he is not to be obeyed or recognized as an officer would be. Right, so he doesn't have to say, okay, officer so-and-so. You just say, all right, well, you do have to follow the writ, but he's not going to be. And basically what this is saying is that you don't just automatically turn him into a cop when you do this, or a sheriff. He must show his authority and make known his business, if required by the party against whom the writ runs. Okay. This is important. This is what every single cop must do as well. Every sheriff, everyone pretending to be or is an officer, constable, sheriff, sheriff's deputy, coroner, and marshal. Or in this day and age, even like FBI agents, who obviously have no authority at all because the FBI doesn't have a charter to operate within the United States of America. But I digress. Basically, anybody who's wearing a clown outfit, to put it that way. Okay, that's his color. The clown outfit is the color. The badge is the color. The authority is the writ. So he must show his authority and make known his business. If an officer does not show a proper warrant, say, for arrest, then he cannot arrest you. Now they say, well, if he has RAS, which stands for reasonable articulate suspicion, then the officer can arrest you. Well, technically they can't, because the officer can only arrest if they actually have witnessed something, not if somebody else calls in and says, there's suspicious activity. Sorry. The only way that a cop can arrest you on somebody else's word is in case of felony and extreme bodily harm. So, give me an example of that. Say you're walking down a city street and two guys come running out of an alley in front of a cop or in front of a sheriff or in front of a marshal, doesn't matter, whatever, in front of a constable, right? The two men come running out from the alley, two guys, and the cop witnesses one of them shoot the other. Okay, the cop witnessed that. That's a felony. It's manslaughter, murder, depending. And then he has the immediate authority to arrest, as would anybody else who saw that. Anybody has the authority to arrest when they see a felony in progress. Okay? Fine. Now, if only one guy comes running out of the alleyway and turns, sees the cop, and then yells at the cop and says, hey, I just saw somebody steal somebody's purse, let's say. And then the cop goes running around the corner and they see some man walking down the alleyway with a purse. But say they don't see anyone that, the purse would have belonged to, like there's nobody else there. Can the cop arrest him? The answer is no, because the cop didn't actually witness it. And it's not a felony and it's not immediate bodily harm. Now, there's some variance to this, but if you take it from the logical standpoint that the only way a cop can arrest upon somebody else's word is basically an aspect of felony or bodily harm. It can't just be like, oh, well, there's some suspicious guy walking over there and he's like recording people's houses. Who cares? The cop cannot arrest that man or woman for doing that. Not to mention it's a violation of the First Amendment. But that being aside, if the cop comes up to someone and the guy's like, say, already put away his cell phone or put away his recording device and he doesn't have any recording, like he's not recording when the cop sees him. All you have is a third party stating that somebody did something to a cop or basically to a 911 call. Well, that's not RAS. You don't have reasonable articulate suspicion because you didn't witness the thing happen. And cops tend to forget this. In fact, they think they can do whatever they want to based on a 911 call. They can't unless they actually witness something. So pay attention to that, understand that, and do some due diligence and look up cases in your state regarding the right to arrest and specifically what happens after arrest, the duty of the officer after arrest. Okay. Now I know I just digressed a little bit, but this is kind of important when it comes to the whole totality of what can or cannot be done. Okay. In regards to powers. And since we're talking about, and the indifferent person must be named, so on and so forth. A person authorized to serve a writ has all the powers and he must show his authority and make known his business. That's what all cops must do. Show his authority, meaning the arrest warrant. And by the way, not a copy of one that isn't signed, not one that doesn't have attached to it a affidavit as to the validity of why the warrant issued, right? Because that's protected in the Bill of Rights, people. You have to have a signed warrant and it has to have by oath or affirmation attached to it why the hell the warrant was issued. Some warrant without being signed, printed off of some stupid cop's computer is not authority. None, zero. He doesn't have it. And they'll kind of realize this too if they try to push the matter and you really do know. You're like, that's not a valid warrant. It's not signed. And where's the affidavit? And I'm going to stand on my rights. And if you think you're going to try and take me, well, then this is going to be a gunfight. They'll back off because they realize they don't have authority. Okay, and if required by the party against whom the writ runs. And that's the point. If required by the party against whom the writ runs. So when the person being being approached by the officer who he's going to serve, if that party says, hey, hold on here. I require that you, show me your authority and make known your business. It's because it says if required by the party against whom the writ runs. That is an aspect of knowing your rights. Because he who slumbers on his rights has none. If you don't exercise your rights, you don't fucking have any, okay? So you have to be able to exercise your rights. You have to know what to say to cops. You have to know what they're bound by at all times. And you have to know what your rights are as far as what they can or can't do based on the Bill of Rights, based on state bills of rights, based upon common law case holdings, and based on even older foundational documents like the Magna Carta. Once you understand all of this, you have all the power because they're just a public trustee, right? And they only can act if under very limited circumstances. Okay. And last bit here, no one is authorized to deputize a person to serve process except by authority of statute. So what does that mean? No sheriff can just deputize someone off the street and say, here, and then hand him a writ and then say, go execute this on that guy over there or whatever. Can't do that. All right. So only by authority of statute, which makes sense because the authority of statute is the aspect of what the government can do and how the powers from said government should be executed by said officers. Okay. All right. Let's skip down here. No person can execute process of his own favor. We've said this multiple times, but this is just another example. And oh, by the way, guys, I mean, some of these cases are probably going to be overturned, but some of these cases may not be, and some of them, because they're common law, probably will still be in full force and effect. So whenever you see the footnotes, so 6 would be this one down here, Shandecker versus Bros. This is an Illinois case. And you can still go look these up. See, just go look at the case, how it worked out, and read the holding of the judge. It should be interesting, fair, right? A person who is not an officer and who is not expressly authorized by law cannot legally serve process. A summons directed to a marshal cannot be served by a private person. The return of an unofficial person must be verified by his oath. An indifferent person bearing the same name as that of plaintiff served a writ, and it was said that he would be presumed to be the plaintiff and the service not good, right? So, all right, you got two guys named John Doe. One's the plaintiff and the other one isn't. Well, John Doe gives to John Doe, the indifferent person, that's the same name, and said, here, go serve this. Well, that's not good service. In exercising his power to authorize a person to serve process, it will be presumed the officer selected a competent person, meaning like the judge or whatnot. So you got to pick a competent. It's presumed that when a court does it, that the person will be presumed competent, meaning like you're not going to say, oh, yeah, go have that infant serve, whatever. All right. Hence, it need not be stated that the person is of age. Right. Same thing I said. Oh, I noticed that is of age. Notice they don't say age of majority. Because when you go back farther into these treatises, they use the proper term, is of age, not is of age of majority. But in California, it is held that the affidavit of service of summons by an unofficial person should recite that he is more than 18 years of age. Okay, fine. The son of a plaintiff is a suitable person not being a party to the action to serve summons. The competent person required by statute to serve a justice's summons must be selected on sufficient inquiry to determine his competency. Right. This is the aspect again of just, the sheriff can't walk up to somebody, deputize them, and then say, go do this. There has to be some sort of sufficient inquiry. And that's usually done by the court if you're going to actually have that done by a competent person and an indifferent person instead of a regular officer. Okay. All right. So we're going to skip down. Section 99, time of service. This topic is also controlled by statutes as to the length of time of service of process. The constitutional declaration that, quote, no one shall be deprived of life, liberty, or property without due process of law, close quote, something all of you should memorize, guarantees to everyone due notice of any legal proceeding against him. In each state, the duration of time between the service of the notice and the day when he is to appear and defend is fixed by statute. The cases to be presented in this section concern matters incidental to the subject and will be found of much practical importance and use. Now, as the rest of this chapter deals with minor points of law regarding dates and times within service being valid. So I'm going to skip down a little bit. But again, just to make a point here about this, no one shall be deprived of life, liberty, or property without due process of law guarantees to everyone due notice of any legal proceeding against him. It also guarantees that everything that I just said about cops and warrants, okay, that falls under this clause. All right, skipping down. Chapter 22. The manner and sufficiency of service of process on persons. Reading and delivering and leaving copy at usual place of abode. Attempted service. Same subject, leaving a copy. Definition of the phrase, usual place of abode. Acceptance and waiver of service. Service on infants. Service on miscellaneous persons and bodies. Section 100. Reading and delivering and leaving copy at usual place of abode. Now, what they're calling usual place of abode, I would, in modern parlance, call their lawful domicile. Because they do talk about residence in here a little bit, but it seems like what they're using as the usual place of abode, that definition seems to be more akin to one's domicile and not a residence. Okay, so and what the hell is the difference between these two? All right, a residence, you can have many, many residences, but you can only have one domicile. A domicile is the location of which you intend to always return to. You can also consider it your homestead. You can also consider it the established location of your house. You can also consider it to be the location of which you are a de jure state citizen, right? And you can have as many residences as you want. So if your domicile is, say, in Wisconsin, but you don't like winters, you probably have a residence maybe in Texas or Arizona or Florida or all three. That's fine. But your lawful domicile is still in Wisconsin, okay? So they're kind of using place of abode like that, but just in a general sense. I don't want to say that it's concrete. So, all right, to continue. The law is very guarded as to the manner and sufficiency of the service of process. The officers charged with the duty of executing process do not always know how it should be performed or, if fully informed in the matter, often fail to satisfy the requirements of the law. The cases which will be presented in this chapter will aid much in the determining controversies upon the subject, as previously stated. Now I'm just going to kind of skip down because, again, I don't want to get into all the tiny minutiae of all this, but I will cover some things here. And just some of these are just kind of funny. A person's boarding house where he keeps personal property is his usual place of abode. The defendant being a partnership and sued by the firm name, the service of the summons may be leaving a copy thereof in the firm's usual place, doing business within the county where the action is commenced. Next one. It is to be presumed that the officer served the process within the limits of his jurisdiction, and if the return be silent as to place, this will be immaterial. Service on a person who is not the defendant, who mails it to the defendant, is not service on the latter. Because you got to have clear reason to be doing it by mail. A defendant wishing to avoid service of process, this is really funny. A defendant wishing to avoid service of process disguised himself in his wife's clothes and refused to receive the papers from the officer, who thereupon laid them upon the defendant's shoulders. This was held to be a valid service, and that the act did not constitute an assault on the defendant. So, and that's usually how you do it anyway. I also have a funny story about this, about putting hands on people for service. I had a special master of mine one time process serve the clerk of the court. So the actual voted in clerk of the court for the county. So my special master walks in to the clerk of the court's office, and he looks over in the corner where, it's like seating areas and whatnot. And there's a guy in a uniform standing in the corner holding what appears to be a whole armful of various different folders and things. And it looks like to him that he's probably maybe doing the same thing, maybe doing service on someone. He doesn't think anything about it. Walks up to the desk, says, "Is so-and-so clerk here?" They say, "Yeah." He says, "Okay, I need to see him." And the person behind the desk says, "Well, why?" "Well, I've got some papers I got to give to him." Okay, just a second." So walks back, goes, gets the clerk. Clerk comes forward. My special master says, "Are you John Doe, clerk of the court?" Guy says, "Yeah." And my special master says, "Here, I have service for you." Now, that's the last thing you want to do. But him having kind of, in a sense, being like this only like the second or third time he'd done this, he kind of went a little bit lackadaisical. And he said, "Here, I have service for you." And he handed it out. And the clerk said something to the extent of, "Well, I don't want that." And so my special master turned around to the guy that was in a uniform in the corner, and he giggled at him, and he said, "Look, he's refusing process." And the officer stepped forward, grabbed the paperwork out of my special master's hand, and shoved it into the chest of the clerk, and said very loudly, actually, for everybody in the office to hear, "You've been served," which was hilarious because my special master broke into laughter and tried to hide it. And quietly said to the officer, "Thank you," and then quickly walked out of the office. Now, it turns out later that he found out that the guy was actually a federal marshal because he looked at it and he looked up his badge as to what it was, and he's like, I didn't recognize that badge, but I went home and I looked it up online. He said that was a federal marshal, and he said that was really funny, and he told me the story and all about it. And my special master at that time was a character, and really good at telling stories, so I cracked up as well. But it goes to show that this whole thing about laying hands on, what did the federal marshal do? He grabbed the paperwork out of the special master's hand and shoved it into the clerk's chest, laid hands on him with the papers in between, and said, "You've been served." Now, when you pull your hand away, and if the papers fall on the ground, doesn't matter. The papers have been given to him. He knows it. They're within reach. Just like if you walked up to somebody's desk and you say, "Are you so-and-so?" "Yes." "And you've been served," and you put it right on the desk, that's fine. You don't have to touch the papers to the person. That's not what I'm getting at. I just think it's hilarious that there's this aspect that will not constitute an assault on the defendant, that the federal marshal did that. And in also doing so, gave a valuable lesson to my special master as to how you're supposed to do service. You're never supposed to open up the discussion when you're trying to serve someone and give them an opportunity to deny service. Once you know that's who it is, you simply either do what the federal marshal did, which is shove them in their chest and say, "You've been served," or if they're at a desk, you can drop them in front of them, or you simply say, "You've been served," and if you don't want to get physical, you just say, "You've been served," and you just drop them literally in front of the person at their feet. That's valid service. So what you do not want to do is say, "I have service for you." Well, then you're giving the option to the one who you're serving as to whether they want to pick it up or not. So you don't want to be in that position. You just want to say, and here's the other thing too. Say my special master would have come into the office and say the marshal wasn't there. The one at the front desk said, "Oh, who do you want? Oh, you want the clerk? Well, he can't come out right now." And then the next thing you would say is this the clerk's office? And if that person behind the desk would say, "Yes, this is the clerk's office," you'd say, "Very well, what's your name?" And, Sandy Lou, whatever. Okay, you write down just real, and if you're the process server, that's what you do. You write down, Sandy Lou on your little notepad, and you say, "Okay, the clerk of the court, Thomas, whoever, has been served, and you drop it on Sandy Lou's desk and you walk out. Now, in your affidavit, in your process service affidavit, what you write down is that I process service Thomas whoever clerk on such and such a date by leaving the said whatever at the desk of Sandy Lou, who at the time was apparently in charge of the office. Because if they do not let you pass, apparently they're in charge. So you say, okay, apparently they were in charge of the office at the time. That's valid service on the clerk, even though you didn't get to see the clerk. Okay, that's how you get around that, if indeed you get stopped. And that goes for anybody. If it's even, say, the only place you can possibly figure out to serve someone is, say, at their work, but you come to a, I don't know, military guarded, gate at the front gate, right? Won't even let you get past the front gate. Won't even let you get on the property. Great. I don't care. Hi, what's your name? Oh, I'm so-and-so. Rent-a-cop. Okay. So-and-so, John Doe, rent-a-cop. I have service for Jane Doe. Well, you can't go in. Okay. Drop it on or near Mr. Rent-a-cop's feet and say, Jane Doe has been served as per, whatever rent-a-cop. And do exactly the same thing. Because apparently they were in charge of the whole place. Right? Same thing, same deal, just slightly different because you didn't even get in the building. Doesn't fucking matter. They're apparently in charge of the whole place. That's what you put into the process service affidavit. Okay. Just make sure you get their name kind of before you walk out so that you're not having to ask them their name after you drop it off, because I can guarantee you they probably won't give it to you. So always try to get the name prior to doing that little sidestep. All right. Next one. Service of a writ on a person having a different name from that of the one against whom the writ issued is not good, meaning can't have two different names. And this would still also go with aspects of warrants in the day and age now when all they're doing is putting out warrants for the apprehension of all res of the estate, and it's in the estate name or it's in a constructive trust name of the court case. And what they're doing is they're going to go then pot the body, which is part of the res of the estate, into a jail. So in a sense, it's kind of like a writ of execution instead of actually an arrest warrant, even though they won't tell you that. Then what happens, you could say, well, that's not my name, clearly. And you can give them some sort of reference as to either statutory authority or maxims of law or a treatise and say that my Christian and surname clearly cannot be in all capital letters. You have a writ of execution for a fiction. I'm not a fiction. And so therefore this warrant is invalid, and tell them to fuck off. Now, depends how far you want to go with that, but could you technically tell them to fuck off with deadly force? The answer is yes. Do I suggest you do that? No, but I'm just saying there will be an example, I think I recall within this treatise, of a situation of which a marshal tried to serve a warrant upon someone who was defective, and the someone decided to shoot the marshal in the chest and kill him. And the court actually ruled that that was lawful self-defense because the marshal had no authority. He came with his color, but he didn't come with any authority because the authority that he brought wasn't valid. So that's why I know you can do that, because it's literally within this treatise. But anyway, we'll get to that. I don't think tonight, but probably the next class. Okay, so name, different name, not good. All right. Where the law permits a fictitious citation in certain cases, meaning the name of a fictitious entity, whether it be whatever, usually in all caps, in the place of a real one, it is necessary that the formalities required to operate the legal fiction be strictly observed. Okay, so got on the side here, what is a legal fiction? And I also put it into the definitions. And this is the only one I did not take from Bouvier's, so just be mindful of that. Legal fiction. A legal fiction is an assumption and acceptance of something as fact by a court. That can be anything, guys. Is an assumption and acceptance of something as fact by a court. What's that also called? A presumption. although it may not be true. To allow a rule to operate or to be applied in a manner that differs from its original purpose while leaving the letter of the law unchanged. Reasons for creating a legal fiction can vary, but legal fictions are typically designed to achieve convenience, consistency, equity, or justice. They very rarely ever actually are designed to achieve justice. But anyway. For example, where a court cannot exercise in personam jurisdiction over a defendant, it can bring that defendant under its jurisdiction via quasi in rem subtype 2 jurisdiction. What the fuck is that? That is exactly what they do all the time. That sentence right there. Via quasi in rem subtype 2 jurisdiction. What is that saying? They're saying they're going to attach the estate of which your body is part of and bring your ass in that way. That's literally what that is. Are they going to ever describe what that is? Fuck no. But that is what that is, because that's the only other thing that they're doing. Now, I'm going to read that again because it's extremely important. For example, where a court cannot exercise in personam jurisdiction over a defendant because of why? Because, I don't know, maybe because we're one of the people and we've never done a harm and there's no contracts with the corporate state and we don't consent to be subject to the jurisdiction of fucking foreign Roman civil law from courts and governments that are corporations with their own fucking Dun & Bradstreet numbers. Maybe all that. Yeah. Okay. To continue, it can bring that defendant under its jurisdiction via quasi in rem subtype 2 jurisdiction. Right. That's creating a constructive trust in the name of the court case, attaching the estate to it because it's been abandoned, and then saying, all right, it's an in rem action. What does in rem action mean? It means against a thing, against the res. What's the res? Your fucking body. But you're dead, because that's the presumption. You're dead and lost at sea. You're an infant. No one's come to claim your estate. This is how they do this, right? The latter is a form of personal jurisdiction that uses a defendant's property to satisfy a claim against them. What's the property they use? Again, right, the body. It is a legal fiction because it treats the owner of the property as a defendant, although the subject of the suit is technically the property itself. Right, the body, which is why they have to create the defendant's name in the suit, in the criminal suit, in all caps. Because it's not a proper name, right? Another common legal fiction is legal personhood or corporate personhood. This, we all know what that is. Legal personhood also is an aspect of, say, a corporation soul or other various different things. Incorporation of business required the creation of the legal fiction of corporate personhood so that corporations could sue and be sued in courts, right? We all know what that is. Fine. But guess what? Your legal fiction is not a fucking corporation. Anybody that teaches you that is a moron. It's your estate. It's still in all caps because you're considered dead, well, presumed dead. It is not a corporation. Corporation has charter. Corporation has stock. Corporation somewhere is registered as such with the state. You are not a corporation. Your legal fiction, the one that they use, is also not a corporation. The name on the BC is the estate. The name on your Social Security number is one of the trusts, and then the name on all of the court cases are other forms of constructive trusts, which they are using and creating in the same way that I just stated here in the red underline. Okay? Got that? Probably not, but anyway. If you got to keep going over this, do it, because this is what they're really doing. Okay, so back to here, legal fiction. Did that. So, that the formalities required to operate the legal fiction be strictly observed. This is how you can crush them, because they never strictly observe them. They do all this shit by presumption, and most of these morons don't even know the actual reasons of what they're doing. So you can crack them upside their head. And a side note for that, just I'm not totally getting off point here. From the standpoint of the aspect of jurisdiction, I posted a few things into the VSOF Gab group not that long ago. All right, this being one of them, and then this being the other one. Now, I think I covered this last time, but just real quick, I'm going to go over this. All right, this is an important aspect of citizenship. This is the difference between, well, I'll just read it, whatever. And I can give you guys the law book that Norm Macdonald specifically says that everyone should read. And you can find it in the lectures that I've posted of Norm Macdonald on the VSOF platforms. But anyway, citizenship. A person may be at once a citizen, lowercase c citizen, of the United States and of a particular state, lowercase state, and most lowercase c citizens of the former are lowercase c citizens of some particular lowercase s state, owe allegiance to both governments and are entitled to the protection of both governments. Quote, the distinction between citizenship of the United States and citizenship of a state is clearly recognized and established. Not only may a man be a citizen of the United States without being a citizen of a state, but an important element is necessary to convert the former into the latter. He must reside within a state to make him a citizen of it, but it is only necessary that he should be born or naturalized in the United States to be a citizen of the Union. It is quite clear, then, that there is a citizenship of the United States and a citizenship of a state, which are distinct from each other and which depend upon different characteristics or circumstances in the individual. Close quote. Consequently, a person may be a citizen of the United States without being a citizen of any particular state. And this is the status of citizens permanently residing in the District of Columbia. Got it? Fucking hope so. Because there it is in your face. That's what it is. That's what we're getting rid of. That's what the Vocational Science Freedom Status Doc set fixes. It says, I am a state citizen. I am one of the people. And I am not, under any circumstances, a resident of the District of Columbia. Because I do not consent to have my estate administered by you fuckers over there, by presumption. Thank you very much. I'm claiming it back. I don't want to be any part of you or your filthy democracy. Now get away from me. And if you don't want to get away from me, you're going to have to put up a $350 million bond for potential fiduciary malfeasance of the administration of my estate, which is an offer of contract, which is also within the Vocational Science Freedom Status Doc set. But I wanted to make a very, very clear point of this. All these morons out here saying, oh, you're a state national. You want to explain to me where that term is? No, it doesn't exist. And a national, every single place you find it in USC, always goes back to what? Being a citizen of the District of Columbia. Every single one of them. There is no such thing called a state national. Doesn't exist. Everybody teaches it as an idiot. They've never looked it up. They don't understand. You're just a de jure state citizen. That's it. Clearly is what this says. Now, if you're going to do it, do it. But don't think that you're going to get off or get away from anything else just by knowing this. You have to clearly put this onto the public record, which is clearly stated in the Expatriation Act. And it also states in the Expatriation Act that they can't do anything about it. They have to agree with it. All right, that's the citizen thing. On to the next thing. The following process is to reverse the currency and shock their asses in their filthy private for-profit court system with a detailed explanation as to why this works. Okay, I'm going to read this first, then I'm going to go into the whys. The judges do not want you to hear this, but you never get this from a bar attorney. This was reported to have happened in an LA Superior Court recently. This doesn't surprise me. And I think I heard of this a long time ago from a standpoint of, these kind of like urban legends, but I finally found where it was written down, so I thought, well, at least somebody wrote it down, so I'll go through it and explain this. A woman said 4 things. First, and this is like at arraignment. This is the first, whenever you walk in, and you can do this in front of or behind the bar, doesn't matter. First thing she said, I do not consent to these proceedings. Second, your offer is not accepted. Third, I do not consent to be surety for this case and these proceedings. Now, why is that important? Okay, I'll get to that in a second. Fourth, I demand the bond be immediately brought forward so I can see who will indemnify me if I am damaged. The judge dismissed the case immediately and told her to leave the court. Someone had listened to what she had said, and when they were called to the case, they repeated her words, and the judge dismissed his case, told him to leave the court, and then told everyone else that the court was closed and would not be open the next day and left the court. Right. Okay. I put the explanation into here. Why is this important? Because of what we were just reading, right? Regarding I can't even remember via quasi-in rem subtype 2 jurisdiction. Blech. Okay, what are they up to? I do not consent to this proceeding. This takes away fully any presumption on the part of the court that you are making what is called a general appearance, wherein you would be consenting to the jurisdiction of the court and the form of law being rammed down your throat, which is Roman civil law in the guise of statutes, which actually only apply to infants, which is 1 U.S.C. subsection 8 person, which I've gone over ad nauseum. 2, Your offer is not accepted. This removes the ability of the black-robed priest of El to offer you any benefit from the state, like going to jail, which, yes, they see as a benefit given to you. Now, side note on this one, what you should say to totally close this ability is, I do not accept any offer of contract, any offer that this court, nor yourself, nor any attorney offers me regarding any matter now or in the future. That's how you just take away all of it, but so be it. 3, I do not consent to be surety for this case, and should be the word nor these proceedings. So I do not consent to be surety for this case nor these proceedings. What you are doing here is not allowing the court to hold you as a trustee for the constructive trust that is the court case itself, of which the res comes from your estate. What they are doing is all trust law and probate. See this class for more details on this matter. Number 4, I demand the bond. This one is a fucker for them. You'll see all court cases are bonded, and this is because they are not going behind their full commercial liability when they are charging your estate with commercial crimes. So what they have to do is to bond the case so that they can operate with impunity against you. However, if you are aware of this filthy private for-profit probate fraud system works, you can demand to see the bond. And if you ever do get it, you will see that they used power of attorney against you to create the bond in your name. And if you ever get a hold of that bond, or at least the info on the bond itself, you can instantly call the bonding company and not only cancel the bond, but sue the attorney who took the power of attorney over you to begin with, which is total fraud. Don't believe me on this one? Watch this class to go to my show notes and download all the handouts. One of them is a template to use Open State Records Request Act to obtain the bond information on the case, get the bond info, call the bonding company, cancel the bond, and then tell the judge to fuck off. Okay? This is all commercial. Everything they're doing is commercial. Everything they do in the court system is commercial. It's all there to make money. It's all usury. It's all creation of money magic. All of it. As we just learned by this simple definition of legal fiction, which I couldn't believe they actually put in here. Okay? So, now, with that having been said, let's go back and finish up a little bit of our treatise for the rest of the night, and then we'll call it. All right. Scroll down. Next section. The validity of service of summons on one who is too intoxicated to understand the act will not be sustained, although actual fraud be not intended. And laying the summons on the body of a man who is too sick to comprehend the act is not valid service. I will add to that one that laying summons on the body of a man who is incapacitated by dementia is also not valid service. Just like it would be if you tried to have someone of dementia sign something, like sign that they accepted it, or signed a will, or signed something else, right? If someone's too sick, incapacitated, drunk, or literally their brain's gone, it's not going to be valid, right? Okay, to continue. Quote unquote, personally served, as used in statute, means personal service as distinguished from service by publication, which we already talked about how to do publication. If a person declines to receive from an officer a paper presented for service, the officer may place it in any convenient place in the presence of the party, and such act will constitute valid service, right? As I already said, drop it at their feet, drop it on the desk, shove it in their chest, like the marshal did, whatever. Okay, that's it. Done. Service is done. Service by mail is only valid when the conditions on which it is authorized exist and are made to appear, as I said before. You don't want to go doing that when you can actually find the guy to serve, right? There is an obvious difference between a total want of service of process and a defective service, as to the effect in judicial proceedings. Where there is no service, a judgment is quorum non judica, which means it doesn't have any judicial power, and, of course, void. Defective service of process gives the defendant actual notice of the proceedings against him, and the judgment, though erroneous, is valid until reversed by a direct proceeding in an appellate jurisdiction, and its validity cannot be questioned collaterally. Chad asks, drunk, does that include drugs? Yes, it does. So if somebody's tripping balls, you can't serve them. Section 101, same subject, leaving a copy at quote-unquote usual place of abode. Okay, this is where it gets into the domicile thing. Definition of process. To leave process with a member of the defendant's family at a distance of 500 feet from his dwelling is not a compliance by the statute, which required the process should be left with some member of the defendant's family, quote unquote, at the dwelling house. The quote unquote usual place of abode of a defendant is his present existing dwelling or the present and usual and customary place of his abode. Again, this gets into, that is damn near the definition of domicile. Okay, skip down a little bit. The phrase usual place of abode means the usual place where the defendant dwells. Eo intent. Wait, hold on. Insanti? I get that right? Eo insanti? Never heard that one. I'll have to look that up as far as Latin is concerned. That the summons was posted at not a place of casual abode, but of one present abiding. Right. Again, it's like the difference between being domiciled and resident. When the law provides that notice may be posted on the front door of the party's usual place of abode in the presence of the family, the intention evidently is that a person against whom the notice is directed should then be living or have his home in the said house. He may be temporarily absent at the time of the notice is posted, but the house must be his usual place of abode so that when he returns home, the copy of the process on the door will operate as notice. By this expression, the usual place of abode, the law does not mean that the last place of abode, for a party may change his place of abode every month in the year. See, okay, so this is almost like a contradictory thing of the aspect of, because up top it sounds more like domicile, and then right there it sounded much more like residence. So, anyway, I'll just leave it at that. So it's a little ambiguous as far as the definition. A defendant had 18 months before the service of process by leaving a copy thereof with a member of his family in Sioux City, gone to the Black Hills, intending to make his home there. His family remained at Sioux City, but he had planned and always intended removing his wife and children to his new home as soon as he could. He engaged in mining and other business in the Black Hills and built a house and shop there. He also voted and sat on juries there. He visited his family at long intervals, but never abandoned his purpose to remove them to Dakota. Upon these facts, the court said, we think that actual residence with the purpose and intent that it is and shall be permanent fixes the legal residence contemplated by the statute providing for service of original notices of actions by a copy delivered to a member of defendant's family at his usual place of residence without regard to the place of residence of his family. We know of no rule that fixes absolutely a man's residence at the place of residence of his wife and family. A presumption may arise that his residence is with his family, but that presumption may be overcome by evidence showing the fact to be otherwise. And so this is a very long-winded way of saying just because someone's family might be hanging out someplace doesn't mean that that is necessarily another member of that family's lawful domicile or abode. Okay. Skip down a little bit. Proof of the signature of one accepting service of a writ is sufficient. So if you sign for a writ yourself or someone else signs for it and says, yep, I got it, that's it, done deal, which is kind of what you do with registered mail. But again, only if you can't serve the person by regular process. The Supreme Court of Texas declared an acceptance of service written on the back of the petition to be sufficient filing of acceptance under a statute providing for such matter. A verbal acknowledgement of service is not valid, meaning, oh yeah, I got that. Or, okay, yeah, leave it over there, or whatever, right? It must be in writing and signed. So you'll have a process service affidavit of an officer saying, yep, I served him. But this aspect of declaring an acceptance of service is different. There's certain statutes and certain aspects of various different court rules that say that if you... And in statutes, modern statutes, it's called waiving service, that you waive service. So what that means is that you're fully ready and capable and ready to defend this. You already know what's up. And you're basically saying to the other attorney and to the court itself that, hey, I'm waiving service. You guys can just mail stuff to me from now on and I'll take care of it, right? Meaning you are waiving your right to be able to be proved in court by process service affidavit or other means that your right to due process was not violated. Let's put it that way. That's pretty much what this means. Okay. So it must be in writing and signed. The general powers of an attorney, it is said, do not extend to the acknowledgement of service of process, and he cannot thus bind his client. Interesting point there. So anybody want to try and explain to me how the attorney takes power of attorney over you, signs bonds for it, which then the court uses to make money? What? Anyway. But where the attorney, well, actually, I could answer that question. It's by presumption that you're an infant. But anyway, to continue. But where the attorney accepts service, its authority to do so will be presumed. Meaning, same thing. So if attorney accepts process, okay, then everything can be mailed to the attorney, and you don't have to worry about continuing to serve the plaintiff or the defendant, right? Vice versa. But in Georgia, the acceptance of service of process by an attorney is held to be sufficient to authorize a judgment in personam in an attachment suit. So again, in an attachment suit, right? So what are they doing? Back here again, what are they doing here? Well, they're attaching via quasi in rem subtype 2 jurisdiction. What is that? That's an attachment suit. In rem, kids. As the res, as the estate. Skipping down, the acceptance of service of summons waives the defendant's right to object that the summons was erroneously directed. Again, what you're doing is you're waiving all your rights to demand proper service and to protect your due process. Once you do this, if you were to ever do this, you're waiving all your due process rights, basically. And that's what this means. The acceptance of service of summons waives the defendant's rights to object that the summons was erroneously directed. So you can't attack the summons, you can't attack the writs, you can't attack anything if you were to do this. The acceptance of service by one for the defendant may be ratified by the defendant. Okay, fine. The endorsement on the declaration, I acknowledge due and legal service and waive copy, process, etc., properly signed, was held to constitute a waiver of a copy of the declaration and process. Now, what the hell is a declaration? Declaration is part of a suit at law. So you have a suit at law, also known as an action, and then in that action, you have what's called the declaration. The declaration is the totality, pretty much, of the suit of what you're saying against the other person. If you want to know all of the different parts of a declaration, go watch the ins and outs of court class posted on the Vocational Science of Freedom platforms if you guys want to know exactly what it is. And I think I do actually have specific classes between what is a declaration and what is a bill in equity also. Okay, no waiver of process or acceptance of its service should be considered by the court to warrant proceeding in default of actual appearance unless it is clearly shown that the defendant was as fully apprised of the nature of the action and the consequences of a judgment against him as though process had been issued and been duly served. Nothing should be left to conjecture. Too much opportunity and inducement are offered for imposition and fraud in a defendant who surrenders his right to due process of law. And that's the reason why you should never, ever do this. But, get the point. No waiver of process or acceptance of its service should be considered by the court to warrant proceedings in default of actual appearance unless it is clearly shown the defendant was as fully apprised of the nature of the action, so on and so forth. Ibid. So again, he's got to totally show that, yeah, he did waive his rights before you can literally do a default judgment against them, okay? And yeah, I'm pretty sure that was the last one. So then we get to chapter 23, which is where we'll stop, and I'll make a note, 250 page for tonight. And is there anything else of curiosity, questions that anyone wants to ask, or did I seemingly miss anything that anybody wanted clarification on? And if not, I just want to make another little notice here as far as what's up for on the Revolt server. There are quite a few updates that have come up with the Revolt server recently, and I just want to make everybody aware of it. That also the fact that the Revolt server is how we communicate on a regular basis in the VSOF, and to do so, when you get here, you'll come to the landing pad, and this will be where you're at, and then you want to go to start here, and you want to download this welcome package. You can also download the welcome package and a lot of the show notes on most of the platforms. I am updating the rest of the links to the mega link specifically to the welcome package. So if you want to join us on our Revolt server and join in the discussions of all of the rooms, you got to download the welcome package either here and get the link. The link will bring you to here. You set up an account, click it back, then go to landing pad and then grab the welcome package and then download it. It'll walk you through all of the communications. Also setting up a free Proton email, setting up your own free Mega account, and obviously getting on here as well. And seeing as how we are 3 days away from probably the craziest election that I certainly have ever seen, There probably is a lot of things that we can go over next Saturday based upon what may or may not happen. And just another little shout out. Thanks, Viper, for giving a shout out to the VSOF on the Charlie Ward show the other day. You guys can go check out Viper on his show. It was Charlie Ward is back with Shade Panel and Drew, and the link is in the Revolt server if you want to come check it out. This is what Revolt looks like. I won't get into all of it. I've shown you guys before, so I just want to give it a general look as to what it looks like. And so chat says I can't download anything in the Revolt server. Okay, lower right. If you're running a PC, all right, what you want to do is you want to go down in the lower right hand corner, and you want to click on your little up arrow, which basically says show hidden icons. Go to your Revolt icon, which will just be the white R. Right click on it and then go to restart Revolt. It'll restart the whole entire app. It'll update the entire app, and it'll also update all the rooms that you're in. Now, then you should be able to go back and then click on anything that anybody has posted or anybody has uploaded. And so I was just going to give an example. So if you want to like download somebody's videos that they've posted onto our Vault server, if you want to download somebody's little MP3s, or if you want to download Viper's case against federal judges, then all you do is come here, click on this, and you should be good to go. Now, I'm not going to say unequivocally, because Revolt is obviously a platform that's in process of being created. We got in kind of early since we've been kicked off of Discord, and Gilded wanted to go full communist and change their user and license agreement to start mining our data. We had to get off of there as well. Revolt is open source and it is private. Revolt is not selling anything to anyone as far as your information is concerned, and that's why we're now on it. So Chad also asked, is the Gab post also in Revolt to review? No, but I can drop it in the main chat right now, actually. So if you want. And of course, which one were you talking about? Were you talking about the court one? Well, okay, I guess I'll just do both. So I will share and drop that into main chat for everyone, and then I will drop the other one into main chat for everyone. Never said I'll try that, but I'm trying to download on my mobile device. It either says I need a password or isn't available when it takes me to Mega. Oh, well, downloading things off of Mega and downloading things off Revolt are two entirely different matters. If you have a link to Mega that says that you need a password, please tell me where that link is, because it might possibly need to be updated. I just need to update those, and then they seem to work perfectly fine. I don't know if there's a time limit. I don't set time limits on my Mega links ever for that specific reason, or it might just be an issue with your phone and compatibility with Mega, because I do know that Mega sometimes some phones don't like Mega, let's just put it that way. And the establishment hates Mega, let's put it that way as well. So you just got to keep that in mind. But everything that you do with the VSOF is always, always better to be done on a PC. You guys should really try and get off your phones as much as you possibly can. And honestly, you should really throw them into the fucking river. But I know you guys, live off your phones and so on and so forth. But as much as you can get away from as possible, better off. So, yeah. Okay. So with that, I thank everybody for coming. Hope you guys learned a lot. Hope you like my little stories tonight. And this has been the reading of a treatise on the law of jus writs and process in civil and criminal cases. And we will continue this a few more times, and then I will probably move on to another treatise or to another class and let you guys finish reading off the rest of this treatise on your own, which is what I usually do. I don't usually go through one of full 700 pages. And also, side note, since it looks like the cabal might be starting to attack archive.org, I highly suggest that anybody who hasn't done so get onto archive.org and start downloading every single treatise you possibly can off of that site. And if you want all of the treatises that I've ever collected off of that site for the entire 30 years of doing this, you can become a lifetime member of the Vocational Science of Freedom. For 130 rounds of silver, you get my entire hard drive, which is 800 gigs plus of information, including every book I have ever found. So, have a wonderful weekend, guys. I will see all of you next Saturday. Let's hope communism did not take over America when we get back. And until next time, as always, stay safe and stay sovereign.
Oh, say